Overview of Promissory Estoppel. I lend you £100. You are under a contractual obligation to pay me £100. Later on, you explained how it's tough being a student, and I agree, in order to help you continue your studies, that I will accept £75 in discharge of the debt. You pay me £75 and go and buy a new textbook that you could not afford before. Later, I rethink my generosity and sue you for the extra £25. Do I have a case? The issue to discuss in such cases is, could the promise be enforced despite the lack of consideration? In the last lecture, we learned that in Jorden versus Money, courts held that estoppel cannot be applied to promises. However, in Hughes versus Metropolitan Railway Company, 1877, the House of Lords gave effect to the conduct which amounted to a promise as to future conduct. The landowner Hughes served notice on the railway company to perform repairs within 6 months on the property it leased from him. The railway company said that it would carry out the repairs, but before it did this, it wished to hear from Hughes on its proposal for Hughes to buy railway company's leasehold interest in the property. The parties entered into negotiations, but they did not arrive at an agreement, and Hughes sought to eject the railway company from the property 6 months after it had served the notice of repair. The railway company performed the repairs 2 months later. The House of Lords held that Hughes' conduct had led the railway company to believe that Hughes would suspend his strict rights under the lease during the period of negotiation, and it would be inequitable to allow Hughes to later enforce those strict rights. In a sense, Hughes was held to have promised that he would not treat the 2 months of negotiations as counting towards the 6 months in which the railway company had to repair the property. Consequently, the railway company had completed the repairs in time. The decision in Hughes was largely ignored until Lord Denning brought it into the limelight in Central London Property Trust Ltd versus High Trees House Ltd, 1947, where he said, "The law has not been standing still since Jorden versus Money. A promise intended to be binding was intended to be acted upon, and in fact acted upon is binding so far as its term properly apply." The broad principle is now known as Promissory Estoppel. Let's look at the facts of this case. In Central London Property Trust Ltd versus High Trees House Ltd, 1947, the plaintiff let a block of flats to the defendant on a 99-year lease for £2,500 per year. The evacuation of people from London during the war meant that defendant was unable to sublet enough flats to cover the rent. The plaintiff agreed to halve the rent. After the war, the property market stabilized and the defendant was able to sublet all the flats. The plaintiff asked that the defendant resume paying the original rent, but the defendant refused. The landlord had leased out some flats in London for £2,500 per year, but the Second World War intervened, and unsurprisingly, it was difficult for the tenant to sublet the flats as he had originally intended. The landlord said that he would accept £1,250 per year in discharge of the tenant's obligation to pay £2,500 per year. Lord Denning thought that the promise to accept less was enforceable only so long as the wartime conditions existed. As soon as the war ended and the flats could be sublet again, the landlord could claim the full contractual rate of £2,500 without acting inconsistently with his promise. This was sufficient to dispose of the case because the landlord only claimed the full rent from the end of the war. However, Lord Denning's principle would have stopped the landlord from claiming the extra rent, the difference between £2,500 and £1,250, if he had claimed it during the war years, because the promise to accept less was intended to be binding, intended to be acted upon, and was acted upon. While it was accepted that the relied on promise did not create a cause of action in damages, the landlord could not have acted inconsistently with his promise and claimed the original contract price of £2,500 per year for the war years. The landlord's legal right to the full rent during the war had therefore been extinguished. Let me ask you the question that I asked in the beginning of this lecture. I lend you £100. You are under a contractual obligation to pay me £100. Later on, you explain how it's tough being a student, and I agree, in order to help you continue your studies, that I will accept £75 in discharge of the debt. You pay me £75 and you go buy a new textbook that you could not afford before. Later, I rethink my generosity and sue you for the extra £25. And I asked you, do I have a case? Folks versus Beer and Reselect Move makes it clear that there is no consideration for my promise to discharge the debt. And so there is no contract for the partial discharge of the debt. The contractual obligation stands and you still owe me £25. However, my promise to discharge the debt on receipt of £75 was intended to be binding and intended to be acted upon by you. And you acted on it by paying me £75 and also by buying the textbook. And so, following Lord Denning in High Trees, I will not be allowed to enforce my strict legal rights under the original loan agreement if to do so would inequitably allow me to act inconsistently with my promise. Whether you can resist my claim to the £25 indefinitely is another question. It may be that the estoppel only suspends rather than extinguishes your obligation to pay, and it might be that it can be revived after you have been given reasonable notice. After all, you can, to some extent, resume your original position by selling the book or possibly even getting a refund. Or I could wait until you graduate and you become this successful rich lawyer and then sue you, all within the 6-year limitation period, of course.